I'm Rory Little. I teach constitutional law and other things here. Thank you so much for coming to the Hastings Annual Supreme Court Review and Preview. And I want to say a few things before we get started. We have a great panel today with Professor Radhika Rao and Professor John Abel, and I will give them a completely inadequate introduction because I failed to be able to prepare since I just finished teaching 2.5 hours. So just let me assure you, they are amazingly well qualified. Professor Abel is new last year. That's right. And Professor Rao has been here since she was 7 years old, right? And I've been here longer, pretty obviously, I guess. This is a preview of the next term, but mainly it's a review of last term. And there are a lot of cases, and we aren't going to cover them all, right? We are only going to cover a few cases, some in depth, mostly not in depth, and many not at all. So if you have other questions, first you can get these PowerPoints from us or from the academic dean's office if you want them. My PowerPoints have clickable links in them to a lot of the opinions and other things. And I just wanted you to see pictures of the other faculty that teach common law here at Hastings. Some of you will be available. I mean, some of us will be teaching common law 1 in the spring for first years, and you all will be able to select, I think, exactly who you get. I think there'll be 2 or 3 sections. Common law 2 will also be offered, and we have a visiting professor, Ming Chen, who is teaching common law 2, at least I know, and she is visiting from Colorado. So you have a wide selection of people teaching. Some don't teach. So Matt Coles is not teaching this semester common law. I want to particularly thank Irma Hernandez, whose picture you see down at the bottom right. She is the person who is the events manager for the whole school and does a really amazing job with a whole lot of balls in the air. So thank you, Irma. And also thank you to IT, who makes this PowerPoint Zoom thing possible. I think I don't have anything else to say by way of introduction. Let's see if this works. So I'm just going to give you a quick overview, and then we're going to move to some substantive presentations from Professor Rao and Professor Abel, and then I'll come back. So this is my opinion. This is not real. This is a picture of the court, right? The new court with Justice Barrett in the back right, and they arrange themselves by seniority. It's all very historically based without any statutory requirements. And my question is it just a court divided, or is it an overpowering Trump court that is just waiting in the wings? And we don't know from last term what the answer is to that question, although we have some hints. And I have a theory that I'll tell you about in a second. Last term, the court issued 54 decisions after full briefing and argument. That is a low number. If you think about 9 justices, 54 cases, how many cases do they have to do a year? It's the easiest job in the world, right? That's why they get summers off. It's the lowest number since the Civil War. Last term, they did 53, which is a lower number, but they were closed for 2 months. And they took 10 cases from last term and kicked them into this term. You'd think there would have been 10 extra cases this year. Instead, they only did 54. So it's a really low number. At the same time, they are increasingly doing more work through this shadow docket, which is a docket of so-called emergency appeals, although it's not really, many of them are not emergencies. They are precedental when they issue an order according to the shadow on this motions docket. They count as precedent. There is not full briefing. There is no oral argument. And there is usually not much time between when the case is sort of ready to be decided and it is decided. Whereas in the normal docket, you're going to have months of deliberation internally in the court. So a lot of people think the shadow docket is an inferior way of deciding cases. And there's a lot of concern, and you may have heard yesterday, the US Senate had a whole hearing on the shadow docket and should there be some concern legislatively. All the arguments last term were remote. They're done by phone, not on Zoom, and there's no video. The Supreme Court has never allowed video of any kind. They did provide live streamed audio for the first time ever. You could listen to the arguments as they happen. They're going to continue that this term. through a button that'll finally be on the website of the Supreme Court, as opposed to having to fight your way through CNN. They are also going to hold their arguments in person, but the only people allowed in the room are going to be court law clerks, some court staff, and the lawyers arguing the case. If you have two cases set for argument, the lawyers that argue the first case have to leave the building after they're done. They can't stay for the next argument. The lawyers for the second case can't come into the courtroom until the first case is over. So they don't even let the lawyers stick around. And they've done seriatim questioning for the first time last term, where they asked in order questions. Each justice got 3 or 4 minutes. A lot of people thought this was an improvement on the free-for-all style that Justice Scalia had turned into a sort of trial by combat argument. And Justice Thomas, who hadn't asked more than 2 or 3 questions in 15 years, suddenly he was the second questioner in all the cases, because he's the senior justice, other than the Chief Justice, who's not actually senior in times of time, but because he's the chief. And Thomas suddenly turns out he had a lot of questions. And they were good, smart, probing questions that other justices then would use as jumping off points for their own questions. Most people think it's a good thing that Justice Thomas found his voice. And so they're going to do this term free-for-all argument, followed by some seriatim questioning, and nobody really knows how that's going to work. So we'll see. They're still in the pandemic. There are 3 women on the court. It's only been a year since Justice Ginsburg died. Does it seem longer than a year? A lot happened in that year. Presidential election, insurrection at the Capitol, various other things, pandemic continuing. Justice Ginsburg is on the left, Justice Barrett is on the right. That's just coincidental. Are they the same? You heard an out loud laugh on that one. They're not the same, because Barrett was born in 1972 and Ginsburg was born in 1933. This is obvious, right? Gender does not define the job. There's lots of other things going on besides that, and no one quite knows what Justice Barrett is going to do in lots of cases, and I know you'll hear Professor Rao talk about that a little bit. Here's my claim. This is not everybody agrees with it. I claim there's still a 3-3-3 court. This doesn't mean it's a moderate court, but it means that justices often group in threes. The 3 liberals are on the left. You can see who they are. The horizontal elevation of these photos shows who's senior to who. The people on the far right are the people who I think are on the far right. And occasionally in the middle is a more moderating view of a conservative ideology. There isn't any doubt that Roberts, Kavanaugh, and Barrett are more conservative than the 3 people on the left. And occasionally, some of these justices will vote in blocks that actually lead to different results. Not always. So I have some examples. Last term, there was a case, we call it the cheerleader case, right? The young woman who made sort of scatological criticisms when she didn't get picked for the cheerleading team. She posted them on social media. She wasn't on school grounds when she did that. They took away they booted her from the cheerleaders as a sanction. Does the First Amendment permit that? And the court said, no, the First Amendment protects these comments on social media. I think this is an example of the 3+3 court, because you have Breyer writing for the court, all 6, and it's the 3 votes in the middle, which are Roberts, Kavanaugh, and Barrett, that make a 6-justice majority. Alito and Thomas write other opinions which state a different approach, if you will, to the First Amendment. Whether they're right or not, is up for debate. The Fulton versus Philadelphia case is another case where the court, Justice Roberts now is voting for 6, and he's got the 3 liberals plus Kavanaugh and Barrett. And in this case, Justice Barrett actually writes a short concurring opinion saying, I do not agree with the dissenting views of Alito, Thomas, and Gorsuch, because I'm not sure what to do. I don't like the law as it stands, but I'm not sure what to do in its place, which is Alito, Thomas, and Gorsuch wanted to just throw the precedent out and go straight to the end. That suggestion of caution, at least on this case, having to do with religion, is a small beacon of hope on where the court might go, although you might hear differently from Professor Rao, we'll see. Does every case fit a 3-to-3 pattern? Not at all. Sometimes they do very weird things, right? Here's a 5-to-4, the Arthex case. It's a very important appointments clause case having to do with patent administrative law judges. And Justice Breyer is dissenting with the two liberals. They're pretty consistent grouping, not 100%, but pretty close. But then Justice Thomas also dissents. In the sense he agrees with the liberals, but his theory is different, so his opinion is different. You may recall the Bostock case. This is 2 terms ago when we had Justice Ginsburg. But Justice Gorsuch joined with the then 4 liberals, with Justice Ginsburg on the court, not Barrett, to reach a result that people viewed as a liberal result. I use these terms sort of with some hesitation, where transgender and same-sex persons are now protected under Title VII, even though Justice Alito is screaming in dissent, oh, what about the intent of the legislature? They never intended this. And Gorsuch says, no, plain language controls. So it's in some sense a conservative doctrine used to reach a result that is liberal and not predicted necessarily by the ideology. My last slide, I think. Is this a moderate court? Does 3-to-3 means it's moderate? No, doesn't mean that. There are lots of examples. 3 cases I have right here at the top, which may not get mentioned otherwise. The Buren case basically gutted Section 2 of the Voting Rights Act. They said they're reinterpreting it. It's a flat out 6-to-3 Trump court, anti-voting rights. And Justice Kagan maybe saved up her best verbiage of the term for the dissent in that case. These are clickable links if you want to find them afterwards. The Americans for Prosperity invalidates a donor disclosure law. Again, Roberts for the 6, Sotomayor dissents for the 3 liberals. Cedar Point Nursery invalidates a California law which granted labor organizations a relatively short access to agricultural places to support, to solicit support for their union or their organization. Again, 6-to-3, they called it a taking. A lot of people thought that this was tossing aside some old doctrine. And again, I think an example of a court that is not moderate, a court that is willing to go against precedent. And so maybe that points where we're going to go this term. There are some counter examples, right? California versus Texas preserved the ACA, the Affordable Health Care Act. And now Breyer wrote for 7 people, and the only dissenters were Alito and Gorsuch. And then you have to get used to this reality. The Chief Justice, Roberts, who was viewed as a conservative when appointed, now is not in control of the court. They can do things without him. And they did, as you know, and now you hear a lot about it, in Whole Woman's Health versus Jackson, which was the shadow docket order just a month ago that allowed to stay in operation the Texas abortion statute, even though that statute is undoubtedly unconstitutional under current law. And Justice Roberts dissented, and it didn't do any good. He was shouting into the wind. So that's a description of some cases that were decided last term, but also maybe some indication of where we're going to go in the future. And I'm going to turn things over to Professor Rao, who I think is going to remain seated because this podium is so small, there's no place to put your notepad. Okay, and I'm going to turn this off if I can. I'm sorry, Radhika. I'll put this back up. Or maybe I can turn them all off. I don't know. If I could turn them all off, the audience would see you better. Maybe IT can come up here and turn them all off and let the Zoom thing show. Oh, thank you.
Okay, thank you. So can you all hear me? Yes. So I really like Professor Rory Little's 3-3-3 versus 6-3 kind of categorization. And I'm going to speak briefly about 2 cases from last term and 1 case from the upcoming term. So specifically, the 2 cases that I want to speak about from last term one of them falls into the 3-3-3 category, and the other falls into Professor Rory Little's 6-3 category. Fulton, again, City of Philadelphia, the big religion case from last term. I agree with Professor Rory Little's categorization of that case as a 3-3-3 case. But superficially, the opinion was actually, the ruling is unanimous. on its face, it's a unanimous ruling. All 9 justices agreed that a Catholic social services agency, which had religious views against same-sex marriage, could refuse, it was engaging in the placement of foster children. It could refuse to permit same-sex couples it could refuse to place foster children with same-sex couples, basically on grounds of their religious beliefs that this is not an appropriate relationship. And they argue that they had a right to do so as a matter of free exercise of religion. And the Supreme Court agreed that that they possess such a right, essentially. And Chief Justice Roberts, so the city of Philadelphia's contract with them prohibited discrimination based upon sexual orientation. But Chief Justice Roberts wrote a very narrow opinion for the court in that case. And in his opinion, he said that because the city of Philadelphia's contract permitted exceptions and exemptions for other kinds of situations, that the failure to allow an exemption for the Catholic Social Services Agency on grounds of sexual orientation meant that the contract or the law was not neutral and generally applicable. Why is this important? In this case, the Supreme Court was asked to overturn a really important precedent called Employment Division against Smith. But Chief Justice Roberts says, we don't need to decide on the constitutionality and whether to keep Employment Division against Smith or not, because this case doesn't fall within Employment Division against Smith. Employment Division against Smith says a law that's neutral and generally applicable but incidentally burdens religion, doesn't violate the free exercise of religion. And in that case, you had somebody who was religiously using peyote, but they were denied, they were fired from their job and then denied unemployment compensation benefits. And they said this burdens our religion, and the court held no, a generally applicable law that prohibits, drug use, but that is incidentally burdening you does not violate the free exercise clause. So Chief Justice Roberts, in this very narrow opinion for 6 justices, the 3 middle, moderate, I guess, as Rory is characterizing them, moderately conservative justices in the middle, plus the 3 liberals. Roberts wrote an opinion for those 6. And he's saying, we don't need to reconsider Employment Division against Smith here because this falls outside Smith. Barrett wrote a concurring opinion, essentially saying, agreeing and saying that there's no need for the court in this case. She said, there was no reason to decide in this case whether Employment Division against Smith should be overruled, much less what should replace it. Now, I would argue that even though the opinion is superficially unanimous, that really conceals deep disagreements. Deep disagreements within the 6 who formed the Roberts 6, if you will, as well as the other 3, Alito, Gorsuch, and Thomas. Basically, Alito, joined by Gorsuch and Thomas, argued we should explicitly overrule Employment Division against Smith. But the court, the remainder of the court, felt no need to do so. Why? Because they've implicitly overruled it, I would argue, in Fulton. How? They took an obscure precedent called Church of Lukumi Babalu, which basically held that a city ordinance that barred animal sacrifice, which was a practice that was engaged in by followers of Santeria, an Afro-Caribbean religion that was a target of public animosity. Because the city singled out that kind of animal sacrifice while not prohibiting other forms of secular slaughter of animals, hunting, and so forth, the court held that the law was a product of animus against religion, and so unconstitutional even under Employment Division against Smith. Basically, the court has taken this obscure precedent, which hardly was ever invoked before, and used it to invalidate any law that contains exceptions for secular activities, but not for religious activities. So it's led to a sort of most favored nation status for religion. So once the court's done that, why do they need to overturn employment division against Smith? Because you can basically accomplish the same objective implicitly through the avenue of Church of Lukumi. I would argue that that's actually quite instructive for what might happen this coming term in Dobbs against Jackson Women's Health, the big abortion case, this strategy of implicitly overruling. But before I get to Dobbs, one quick point on the other case that I wanted to talk about briefly, Cedar Point Nursery, the takings case. So what happens in that case? California has a rather unusual law, I think it's the only one in the country, that permits union organizers to come onto an employer's property in order to seek to be able to meet with agricultural workers who work there. And the law permits them to come for 3 hours a day for roughly 120 days in a year. Basically, before the hour before work, the hour during lunch, and an hour after work, so that they can try to, attract agricultural workers to the union activities. But the growers argued that this was a taking of their private property rights, that it took away their right to exclude. Now, those who are going to be taking property, you may very well study takings and property. I teach it to my first years, and we cover the two precedents that are most on point. On the one hand, the court has held that there are laws that effectuate per se takings, permanent physical invasions of property. On the other hand, there are laws that merely regulate property and don't require the payment of just compensation. So there's a case called Loretto, where a landlord was required to permit cable TV companies to place cable boxes on her property. And she argued that that was a per se physical invasion of her property. The court agreed and said just compensation was required. In another California case called Pruneyard, involving a free speech easement, essentially the California Supreme Court held that high school students had a right to go onto privately owned property of a shopping mall to solicit signatures for a petition. The court held in that case, when the mall owner said, this is the taking of my private property rights to force me to allow people to speak on my property, the court said, no, it's not. No compensation required. It merely regulates. In Cedar Point Nursery, the Supreme Court said that this case was controlled by Loretto, the per se takings case, rather than Pruneyard, the regulatory takings. So basically, permitting union organizers to come onto the private property owner's property was a physical taking of their property, the court said, that required the payment of just compensation. What might the state do? Breyer, in his, this was a 6-3 case. The 6 conservatives ruled for the majority. Breyer wrote a dissent. And Breyer suggested that maybe the state could just pay just compensation. In Loretto, just compensation on remand turned out to be $1 for the 1.5 cubic feet of cable boxes. So maybe the state could pay some small sum. What does it, amount to? But it's a pretty radical decision. So I would suggest that in the high-profile case, the court was seemingly unanimous. That was the 3-3-3 category. But in the lower profile, Cedar Point Nursery, the court went with a conservative result, 6-3. What does that portend for the big abortion case next term? Dobbs v. Jackson Women's Health. A couple of things I wanted to say about Dobbs. Number one, I think it is ominous that the Supreme Court took this case, particularly in light of the fact that the court failed to stay the Texas abortion law. So that's sending signals, right? And the parties in this case, Mississippi is asking the court to overrule Roe versus Wade. Number two, the Supreme Court, I think, is probably likely to overrule Roe, but it may do so implicitly or it could do so explicitly. Here, I'd like to take the rather provocative position that overruling Roe implicitly is worse than overruling Roe explicitly. Now that might sound surprising to you. Why is it better if the court overrules Roe explicitly from the standpoint of those who support a woman's right to terminate her pregnancy than if it does so implicitly? I think explicitly implicitly overruling Roe is the worst of all worlds. Why? Because Roe remains in theory, but has been eviscerated in substance. And in that world, we don't have the political consequences. If the Supreme Court explicitly overturns Roe versus Wade, you'll see great political consequences at polls, in terms of funding. In fact, many years ago, when it seemed as if the court was on the verge of overturning Roe in a case called Webster, contributions to Emily's List, an organization that tries to finance more women candidates, went up dramatically. And there was a huge amount of political activism. So I think you don't see the political activism that you see if Roe is overturned implicitly rather than explicitly. Now, you might be wondering, how could the court overturn Roe implicitly rather than explicitly in this Dobbs v. Jackson Women's Health, the Mississippi abortion case? Well, basically, Mississippi enacted a law that prohibits abortion after 15 weeks gestational age. That's the statute in Mississippi that was challenged in Dobbs. And 15 weeks gestational age, they're measuring it from the woman's last menstrual period. So what the state is arguing in this case is, as soon as the law was enacted, there's only one abortion clinic currently in Mississippi, Jackson Women's Health. They filed for a temporary restraining order, and they only perform abortions up to 16 weeks. So the law prohibits abortion after 15 weeks, but the only clinic in Mississippi that performs abortions only for 1 week longer. So what the state is arguing is that this law does not unduly burden the abortion right within the meaning of the most relevant precedent, Planned Parenthood against Casey, that it merely regulates abortion rather than prohibiting abortion by pushing the time 1 week earlier. So previously you could have abortions in that clinic up to 16 weeks. Now you can have an abortion only up to 15 weeks. Now, why does this matter? Well, Roe, the controlling precedent here, basically says a woman has a fundamental right to terminate her pregnancy prior to fetal viability. And viability usually is marked, the earliest would be 20 weeks, somewhere between 20 and 24 weeks. So clearly under Roe, which was the precedent that was retained and reaffirmed in Planned Parenthood against Casey, the controlling abortion case precedent now, under those precedents, this Mississippi law should be unconstitutional because it prohibits an abortion prior to fetal viability, prior to 20 to 24 weeks, at 15 weeks. But the state's saying it merely regulates the time. It's like a First Amendment time, place, or manner restriction, regulating the time of abortions by merely 1 week. So they're saying it's not a ban, it's a regulation. And they're saying it doesn't unduly burden the right because it only pushes it 1 week further. That's the first way. The second argument the state is making in this case is basically they made findings about neurological development. And they suggested that the intentional commitment of an abortion at this stage was a barbaric practice, dangerous for the maternal patient and demeaning to the medical profession. And the state is arguing that developments in medical knowledge of prenatal development have shown that the ability to open and close fingers and sense outside stimulus develop around 12 weeks, so that they're arguing that the fetus may be capable of feeling pain and may be sentient at this point. Perhaps the Supreme Court could alternatively suggest that facts have changed, or our medical technology has suggested that there's been developments in knowledge since Roe and Casey that suggest a new standard. And so it's possible, it seems to me, that the court could implicitly overrule Roe by saying, not that we're getting rid of Planned Parenthood against Casey, which retained and reaffirmed the essential holding of Roe, but merely that we're upholding a law that doesn't unduly burden the abortion right within the meaning of Casey. And Casey reaffirmed Roe, so we're not getting rid of the right, we are just regulating. We're upholding a regulation on that right. And yeah, I think I'm out of time.
That case is set for argument.
That case is set for argument on December 1st.
Right.
So,
Which you can listen to live. Well, thank you, Professor Rao. That was great. Professor Abel has a different set of cases to talk about.
Sure, yes.
See if
I'm
we
going to
can-
try and use the PowerPoint.
Right, bring up your. I think if you get the arrow over here.
There we
Do that, and then you want to do a slideshow? All right. We will take questions. I know some of you have to leave to get to a one-time class. Don't worry, there's going to be some time for questions.
Great. Well, hopefully everyone can hear me. It's good to see many of you from my class, and those I haven't met, it's good to see you too. So I'm something of an interloper here. I don't particularly study constitutional law, but I'm interested in criminal law and criminal procedure. And so there is a big overlay with what the Supreme Court does. But in many ways, the real action in these areas is outside of the US Supreme Court. So I want to talk about three decisions, really only two because I only have 10 minutes. But these are decisions where a previous Supreme Court, like way back in 2020, decided a constitutional issue, and this Supreme Court has to decide how to apply it. And really how faithfully to apply it and how far retroactively to apply it. So I want to start with Edwards versus Fenoy. Way back in 2020, the Supreme Court in this decision called Ramos decided that it violates the Sixth Amendment to be convicted by a non-unanimous jury. In Louisiana and in Oregon, it was possible to go to trial with 12 jurors and to have 10 of them say you're guilty and 2 say you're not guilty and you're still guilty. And so the Supreme Court concluded that this violates the Sixth Amendment, and it looked to the original meaning of the Sixth Amendment, and it also looked to the racial and racist intent of these non-unanimous jury roles. I mean, what was going on is African Americans were allowed to serve on juries, but the rules were written so that their votes potentially wouldn't count, because you could have 10 white jury members vote to convict. And so the Supreme Court said, well, that violates the Sixth Amendment, can't do that. And for sure, you can't have those non-unanimous verdicts going forward. But what about someone who was convicted 5 years ago or 15 years ago by a non-unanimous verdict? Does that person get to challenge the conviction on habeas? Habeas is where you bring in, you say something went wrong at my trial, I want to have a new trial. And there is a really well-established doctrine called the Teague Doctrine that governs the retroactivity of new rules, new constitutional rules. And it says that if the rule is procedural, so the Supreme Court announces some new procedural rule, like you need to be convicted by a unanimous jury, well, that is not going to apply to people whose convictions are final. It's not going to apply on federal habeas, unless it's a rule, what's called a watershed rule of criminal procedure. And watershed rules are supposed to be watersheds. They're of bedrock importance. They're so fundamental that it would be an insult to the spirit of justice for conviction to stand. And the court in Teague, 30 plus years ago, decided this case, used Gideon versus Wainwright. That's an example. To be convicted without access to an attorney, that would violate this watershed rule of criminal procedure. The problem is that no one has ever found a watershed rule. And it's not for lack of trying. Over the years, there have been many efforts to claim that some new constitutional rule is a watershed rule. And that's what the litigant here in Edwards said. He said, look, if there's any constitutional rule that should be a watershed rule that is so important, it's the Sixth Amendment right to be convicted by a unanimous jury. And Justice Kavanaugh, writing for the majority, says, no, that's not a watershed rule. But also, to help all of you defendants out there, we're just going to let you know that there are no watershed rules ever. It's done. I don't want to hear about it anymore. That is the decision, Edwards versus Fenoy. So no one in the future can be convicted by a non-unanimous jury, but if you're serving life in prison based on one of these convictions, you don't have an opportunity to challenge it on habeas. There's another case involving the same doctrine, the same retroactivity doctrine, and that's Jones versus Mississippi. So in 2012, the Supreme Court, in this case, Miller versus Alabama, in 2012, the Supreme Court said it violates the Eighth Amendment for a juvenile to be sentenced to life without parole, mandatory life without parole. Okay. And the idea is that juveniles are different from adults, and juveniles can reform, and to sentence someone to life in prison without the possibility of parole, that would only be appropriate in the rare case where someone is hopelessly incorrigible or like irrefutably incorrupt. And there are various adverbs and adjectives. And then in 2016, the Supreme Court had another case, Montgomery versus Louisiana, and the Supreme Court had to say, well, are we going to apply this rule retroactively to the thousands of juveniles who've been sentenced to life without parole? And the Supreme Court said, yep, we will apply this retroactively because it's not a procedural rule. It's this other thing. It's a substantive rule. Substantive rules are constitutional rules that limit the class of people who can be punished, or they limit the types of punishments that can be given. And so a rule that says the Eighth Amendment prohibits executing juveniles, that's a substantive rule. And so any juvenile on death row now can no longer be executed. It has to bring a federal habeas petition, but it would violate the Eighth Amendment. So many states developed rules for resentencing juveniles who'd been sentenced to LWOP, including Mississippi. And this litigant here, Jones, got one of those hearings. He'd been sentenced to LWOP for a murder he committed as a juvenile. And at this hearing, the judge considered his age and then just sentenced him to life without parole again, and didn't make any findings that he fit within one of this like narrow category of juveniles who are incorrigible. And so Jones said, well, this actually violates my Eighth Amendment rights. The Supreme Court said I can't be sentenced to LWOP unless someone has found that I fit into this narrow category of juveniles. And this judge never said I do or I don't. He didn't make a ruling. And so then we have Justice Kavanaugh again writing for the majority, saying all that the Eighth Amendment requires is that you get a hearing. It doesn't require any particular parameters to that hearing. And you got your hearing, and that's it. And by the way, you can seek clemency from the governor. So don't tell me you don't have a remedy. And so we have Edwards and Jones are they're examples of how I guess I would say like innovations by the Supreme Court in years gone by can be brought to a screeching halt by the new court. And I want to make some observations about the cases. Excuse me, I'm pushing this. So like if you're into literary criticism, you should read these because they're just like wild metaphors throughout. I mean, even the procedural rule is a watershed rule. Justice Gorsuch writes a scathing critique of the like entire edifice of habeas corpus and says that it's gone out of control and it's like an ever-growing haystack covering like a smaller and smaller meritorious needle of claims. And we have Justice Alito talking about the watershed rules. It's good we could like layer metaphors on top of metaphors. So he said a watershed rule is actually like a Tasmanian tiger. So like it went extinct in 1936, but every once in a while someone thinks they saw it. And we're telling you it doesn't exist. So, but if you can get beyond the literary criticism, what you see is like an intense hatred for the process of habeas, of challenging final convictions. And so now procedural rules, like new rules of criminal procedure, can't be watershed rules, so that's taken off the table. But also Justice Gorsuch and Justice Thomas say that they want to talk about eliminating substantive rules. Those should not have retroactive effects. And that'll be saved for another day, but it's on the table. And what it reminded me as someone, I was a defense attorney before this and practiced habeas, is what it reminded me is that the Supreme Court is actually in many ways a backwater when it comes to criminal procedure. I mean, there are so many innovations in state capitals, so legislatures, and in the state courts really working through pressing issues of criminal law and criminal procedure. But the Supreme Court is is stuck kind of relitigating a very narrow band of its own cases and does not see its job as promulgating new rules of criminal procedure. And so it is high profile because of what it is, but if you look at what comes out of it in terms of criminal procedure, and I actually think this applies to the Fourth Amendment cases, they're like very small bore. They're not looking to move the law forward. Yeah, so I mean, that's my own view, but I want to put that comment out there. And then I also want to suggest that there's a lot more than just criminal procedure at stake. When you're talking about, I call it Teague and Tree, but Teague is the retroactivity doctrine. When you're talking about retroactivity, you're really talking about one generation's court respect for old convictions, so the work of state courts, but also for prior versions of the Supreme Court's decisions. And, I think as we contemplate abortion or other precedents that might be on the chopping block, this is something of a dry run because people convicted of murder are not really a constituency not a powerful constituency. And so you get a preview in the habeas context of what the Supreme Court is willing to do to its own precedents. And I think it's very scary, but also not surprising. And so I just want to end with this quote. How am I doing on time, Rory?
You're doing great.
I'm going to do this quote, and if I'm really doing great, I'm going to indulge in one additional case. So this.
You're not doing that.
I'm not doing that great. My initial plan was to talk about the first ever toilet flush during an oral argument, but that's for something else. So here I am reading Justice.
Whose toilet was it? Sorry.
I don't know that is a matter of intrigue, and there probably will be an inquest around that. But so here I am reading Justice Thomas's opinion about this life without parole case, and you get down into the footnotes, and he says he's upset about some of the verbiage, and he says when we're addressing juvenile murderers, this court has stated that children are different, and that courts must consider a child's lesser culpability. And yet, when assessing the court-created right of an individual of the same age to seek an abortion, members of this court take pains to emphasize a young woman's right to choose. It is curious how the court's view of maturity of minors ebbs and flows depending on the issue. And so, when I say that, but when I say that, this habeas and retroactivity issue is a preview of other things, I mean, there's really no need to talk about abortion in a case about juvenile LWOP, but it's just in the air. And I think that, I think that this is an example of how the court will just move to, reassert itself and get rid of precedents it does not like. Anyway, thank you.
Thank you.
Sorry. You got it? Okay.
So I'm going to do one slide and then we're going to get to some questions. And we may have some reaction of the panelists to each other. I made a promise about immigration cases. So last term, immigration is a big part of the court's docket, as you probably know, and it is a big concern in our society today. And I'll just tell you that there were let's just say 6, maybe 7, depending on how you count immigration cases. Justice Gorsuch is getting the assignment in all the immigration cases that are hotly contested, which may show you something about the politics of the court, right? These are not, the hotly contested cases are being decided 6-3. There's 1, 2, 3, at least 3 of them, 6-3, all by Gorsuch. And there were 2 that came out in favor of the immigrant, in favor of the person trying to make a claim, but there were 4 or 5 that came out the other way against the immigrant. So it is not a moderate court on this topic at all. And in one case, they reversed the Ninth Circuit. The Ninth Circuit had a rule that said when a non-citizen testifies at an immigration hearing, the court on appeal should take that testimony as credible, absent some finding by the trial court that it was not credible. In other words, when there's no finding of credibility, we should assume that the immigrant's testimony, which is undisputed by people, or even found credible by the trial, we should assume it's true. And they reversed that, and they said there's no such rule. And the INA does not assume that the testimony of an immigrant at a hearing is credible. It has to be found expressly to be credible, or we're not going to count it. That's a pretty frightening case. That's just one of the cases. I have on the screen, I think, let me see if I can get this bigger. Just a few cases, but the main one that I want to tell you about, because I bet you're interested, is the Van Buren case, which was, again, one of these 3 to 3 to 3, I'm going to say. Justice Barrett's first major case. She did have a majority opinion in a procedural case before this, which was not particularly earth-shaking. This is the case that protects you from what many people do when they're on their laptop, or they're on the laptop of a friend or a spouse or a significant other, which is sometimes we access information that we're able to access, we're authorized to access it, we're not hacking the computer, but it somehow is against the policy of the person who controls the data bank. In this case, it was a deputy sheriff who accessed a criminal history file in order to basically do a private bribe action. So the deputy sheriff was a crook, but they said he's not guilty of a, somehow I'm calling somebody. He's not guilty of a felony under federal criminal law, maybe guilty of other things, because we're going to say, if you're authorized to access it, it's okay, even if it's against the conditions that have been set by somebody who controls the data bank. So, for example, if you go onto Facebook and use a fake name, that's contrary to the terms of agreement. If you lie about anything in a dating profile, if you check sports scores at a desk where your employer says you can't use your computer for anything but business purposes. By the way, the justices do that. So, and one justice in particular, by stereotype, at least we think, does that. So, this is a protective decision. This is a defense-oriented decision saying we're going to construe a federal felony statute narrowly, not broadly. And Justice Barrett writes the opinion for 6, and there are 3 dissenters who come from the more conservative camp, although it's not the perfect 3 to 3 that I set up. There were 2 IP cases, patent cases. I mean, I'll just put them on the board there. Minerva Surgical and Google versus Oracle. Very important, very important. Google versus Oracle, not just millions and millions of dollars, but what counts as fair use under the Copyright Act when you come to software. They assume that software can be copyrighted. They leave that question open for a future case. The NCAA versus Alston case is the one that takes off the cap on what you can pay college athletes, at least in something called educational expenses, which can be a pretty broad term. And now you have high school students suddenly who are making endorsement contracts with commercial enterprisers because they're really good at high school football and they're getting national attention or at least statewide attention. And so people are hiring them to do endorsements. And everybody thinks NCAA versus Alston maybe allows that because they said it was an antitrust violation. The NCAA is a monopoly, or there's a monopsony is the word they use. Not that I understand that. The last thing I'll tell you, a preview for next term. The other case you want to watch for really carefully is on November 3rd. Oral arguments, by the way, start this coming Monday. That's why we do this panel now. The first Monday of October is by tradition the first day of oral argument. On November 3rd, the first day of the November argument session, it's a Second Amendment case. And it's a really interesting case. And I think it's why Justice Breyer hasn't retired yet. Justice Breyer dissented vehemently in the Heller case in 2008, when the court for the first time said there's a Second Amendment constitutional right to have a gun in your home, at least for defense. This case involves, is there a right to carry the gun in public under certain conditions, right? We can still have permits maybe, but what should those conditions be? The New York State condition for a concealed carry permit is pretty restrictive and pretty much puts the burden on the gun owner to show a special need. People think they're going to strike down the New York law, but the more important question is, how are they going to structure the rules for Second Amendment cases? And where do these Second Amendment rights, how far do they go? Where do they lead to? What can we challenge? What gun control laws are okay? So this is a huge case. That's something to look out for on November 3rd. There were 4 Fourth Amendment cases, and usually I do the criminal law, but now that we have Professor Abel on the faculty, I'll just have to fade out on that one. 3 of the cases under the Fourth Amendment went for the defendant. We haven't been able to say that in a long time. But they all have little footnotes that sort of suggest that on remand, maybe the government will win anyway. They're not big 100% victories. And there is a Fourth Amendment case, a Fourth Amendment case that has to do with the authority of tribal police on Native American lands, the Cooley case. And if you're interested in Native American law, that's a case you'd want to look at. So with that, maybe I'll make a small comment on what Professor Rao said, and then we've got some questions online that Professor Rao may want to answer. I'll show you. But in the Fulton case, where Justice Barrett wrote this narrow opinion, which was kind of moderate, and saying, I'm not going to overrule that case that the conservatives want to overrule. I'm not sure what to do. I don't think it's irrelevant that that decision, the old decision Smith, was written by Justice Scalia, and she clerked for Justice Scalia. Now I've checked, she didn't clerk the year that decision was issued, but she has a loyalty to her justice, and she doesn't want to just slap down that case until she has thought about it a little longer. That sort of controlling extra point that isn't present in the abortion context. So I don't disagree at all. I agree 100% with what you said. I would go even further and say she has no restraints when it comes to abortion. Let's take the one question that's online, and then we'll ask the question people here. We've got about 12 minutes until 1:10. You can be late for your class because we said you could.
We write notes.
Tell them to talk to me.
So here's the first question online. Is there any way to argue that a right to abortion is not a constitutional or legal issue at all? It's explicitly a healthcare matter. So why is it even included in the Constitution? Well, actually, Justice Thomas would agree perfectly with that perspective, that the right to abortion is nowhere included or mentioned in the Constitution. So the Constitution doesn't have anything to say on that issue. And that's the position that the state is arguing, that Roe was illegitimate and decided as a matter of constitutional law, an issue that the Constitution has nothing to say about at all, that there is no implicit right to privacy that's protected by the Constitution. Privacy is nowhere mentioned. So if the court takes that position, they will explicitly overturn Roe and say that Roe was illegitimate as a matter of constitutional law, but the Constitution has nothing to say about a right to privacy or a right to an abortion, and that states should be able to legislate on what are matters of, they enact laws governing health and welfare. And if this is a matter of healthcare, then some states might choose to protect a woman's right to terminate her pregnancy. And other states might say that we think that the fetus is a person from the moment of conception, and we want to protect the fetus's right to life and to health. And as a matter of healthcare, we don't think a woman has a fundamental right to terminate her pregnancy. So different states can take different approaches to that issue because states have police power to legislate in the public health and safety.
Yeah, no, of course, the problem is that there are so many other rights that are not mentioned in the Constitution that the court has recognized over time. Even Justice Scalia said way back when he was a faint-hearted originalist because he couldn't support certain criminal punishments that were actually in use at the time of the framing. And the Eighth Amendment, of course, doesn't say any particular punishment should be banned. So even Justice Scalia said, well, there may be some rights. And this is the danger of them overruling Roe, is it's founded on a right to privacy to some extent and an autonomy right. And there are lots of people on the conservative side of the bench who don't want to lose autonomy rights, and they don't want to lose privacy rights. And I think it's much harder for them to overrule Roe and not unravel all sorts of other doctrine. I don't know. Professor Abel, did you have anything you wanted to add, or should we go to the?
No, I'd be happy for questions.
Okay, questions in the audience here before we do have more online here, but anybody here who want to ask anything? Yeah. Could you go to the microphone, because the audio in here doesn't pick up your question unless it's. Thank you. I'm sorry.
Hi, can you guys hear me?
Yeah.
Hi, my name's Alyosha. Thank you for having this panel. My question is for you, Professor Rao. We just actually learned about the Cedar Point case in our property class just an hour ago. And I had among classmates, we were talking about how did the SCOTUS find that there was a per se taking when United Farm Workers have to get permits, have to contract with the police to be and enter into a private residence. Comparing it to State versus Shack, it seems like the union is following very strict regulations to be able to access private property, and yet the SCOTUS still said that, no, this is a per se taking as opposed to government regulation. What are your thoughts on that?
Yeah, great question. So State Against Shack is a case that I teach in property as well. And in a sense, for those of you who don't remember, hopefully everybody studied State v. Shack in their 1L property class. But just in case you've forgotten about it, it's a case, New Jersey Supreme Court case that involved migrant workers who were being housed on a farmer's property. And the farmer basically said that a legal services worker, an attorney, and a social service worker who were coming onto the private property to provide legal and medical services to migrant workers. The farmer who owned the property said, you can't see them except in my office and in my presence. And the lawyer and the social service worker said, no, we should have a right to visit the migrant workers who are being housed on your property in their own quarters, in that private space. And the farmer said, no, you're trespassing. And he tried to kick them off his property. And the police then did so. And the New Jersey Supreme Court said he had no right, because under New Jersey state law, trespass law did not include a right to exclude people who would come onto the farmer's property to offer migrant workers who were living there these essential services. The court relied upon New Jersey state law in that case. But what if the farmer had brought a challenge saying that this interpretation of New Jersey state law infringes upon my private property right to exclude people from my property, and in requiring me to permit people onto my land, the government has effectively taken my right to exclude, and it's got to pay me just compensation. That argument was never made in State v. Shack. It wasn't challenged. And I think had it been made at that time, the Supreme Court would have rejected it. But I'm not so sure what would happen today, because I was thinking, reading Cedar Point Nursery, that this does sound a little bit like State v. Shack. Now, I think that you could distinguish the Cedar Point Nursery rule, because there, California enacted a law that permitted 3 hours a day, 120 days a year, the union organizers to come onto the private property owners' property to speak to workers who are working there. So that seems a little bit different from the kind of temporary, intermittent kind of one-time access or rarer, amounts of access. That's one factor that distinguishes State Against Shack from Cedar Point Nursery that wouldn't perhaps make the court less liable to find a taking in a case like State v. Shack than it did in Cedar Point Nursery. I think the other point that the court emphasized in Cedar Point Nursery was they said that the growers hadn't opened up their property to the public generally. That was how they distinguished the Prune Yard case involving the free speech easement in a privately owned shopping mall. They said the owners of the shopping mall have invited people onto their property to shop, and they can't, once they've opened the property to the public, they really have lost to some extent their right to exclude. I think you could make the argument that the farmer in State Against Shack had opened up his property to the migrant workers who were being housed and living there. And once he'd opened it up to them to be living there, essentially there was no way to access them except by coming onto his property. So that he has given up to some extent the full dimension of his right to exclude people once he's allowed people to come and live on his property. And that seems distinguishable. That court emphasized that point in Cedar Point Nursery from the growers who have people working on their property, but presumably they're not living there full time.
Although some I think were, there's no denying that the Cedar Point case is remarkably conservative in the view of the takings doctrine, and willing to push aside certain precedents that they don't like. Not that other courts haven't done that, other courts have. I think one of the things, it was Breyer who dissented in this case, he said, look, this should be more like a regulatory issue, which would require a balancing of interest, because this isn't invading someone's private residence. This is invading a public, a workplace, not a private house. And the majority had used some analogies to private houses. And it's for a good reason. It's for a good purpose. It's for a legislatively identified purpose that, through our democratic process, we say is a valuable purpose. The majority rejects that. The majority just rejects the idea that this should be moderated by the purpose or moderated by the not private function of the agricultural land, which indicates just a flat out conservative view of the takings doctrine, And if you gave them prune yard today, I don't know where they would come out. Maybe they'd go the other way. Anyway.
It's
It's
definitely
a
a
good
big
question.
win for private property rights
Um,
and a loss for unions.
yeah. Other questions in the room? We do have a couple more online here. Let's just, can we comment on the debate around expansion of the court is one question. Let me read the other one too, and you guys can decide which you want to talk about. Given the dissent in Gundy and the subsequent change in the court, are there other cases coming up that will challenge the intelligible principles standard for non-delegation? Want to talk about either of those?
I mean, I'll be happy to talk about the expansion of the court.
Yeah.
I mean, it's at the point where the court is a political entity, then it's subject to changes like that. And, there's not, I don't think there's a constitutional right or wrong about that, but the more politicized the process is for selecting these judges, the more it makes sense to me to be willing to talk about expanding the court. And 9 is not a magic number. And so I think that, we've turned these judges into, quasi legislatures, and they have an enormous amount of control in choosing their agenda. For me, that's the part that's actually most uncomfortable about this. A normal appeals court, or even some state Supreme Courts, they take cases that are brought to them, and there's some cases that are foisted on them. But this can be the year of abortion, and that the Supreme Court can decide that that's what it wants to work on this year. And next year, with different personnel, it can be the year to protect migratory birds. And that, I think, that freedom in controlling its cert docket is part of what has made it so difficult to watch for me, at least.
The history of the number of justices, right? It vacillated from as low as 5 to as many as 10. But since after the Civil War, it's been set at 9. And of course, we have the President Roosevelt's effort to expand the court as a undoubtedly political strategy to have his policies sustained rather than struck down. And that was a live controversy until 1937, when Justice Roberts maybe didn't switch his vote, and suddenly they started upholding, and the idea of expanding the court disappeared. You may be seeing that today. So, but what I think about this expansion issue is we're going to wait and see, and we're going to wait and see two things. One, what does the court actually do this term? And if it does all of the bad things with the seats that arguably were stolen, right? Because Justice Garland, now Attorney General Garland, never got a hearing. Had he had a hearing, he would have been confirmed. And then when Justice Ginsburg died, suddenly they said, oh, we think you can have a new justice, even though it's a presidential election year, which is exactly what they had argued against with Garland. And they put Barrett on in about 5 weeks. If you view those seats as stolen, and the court is doing something that seems to be blatantly political, then maybe you'll see the expansion really gain more steam. And I think right now, the Biden approach, and Biden is more of a moderate than some people, he is waiting to see what happens. He's not in favor. He said, I'm not in favor of expanding the court. And it may be that the justices will be responsive to that, although so far they've shown no sign of that, right? The Women's Health versus Jackson order a month ago doesn't show that they're afraid of political pressures on them. So I would not like to see the court expanded, but I would like to see the court not used as a political football, which it has been in the last 4 years, in my opinion. So that's my view on this.
And on the court expansion
point,
one last point, public opinion polls are suggesting that the court has lost a lot of legitimacy recently through these high profile actions in the Texas abortion case and other shadow docket orders. And so really it's exercise of the shadow docket, to me, on top of what John was talking about with the court's ability to control its docket, its exercise of the shadow docket is one of the most worrisome, troubling aspects of the recent Supreme Court. And I really think that that's brought the court into public disrepute to some degree. And that, in a sense, could fuel these efforts to engage in court reform. It really looks like it's a court that's running amok, but secretly.
Yeah, the second point I was going to make, by the way, I forgot, is the midterm elections, right? If the midterm elections transfer the majority away from the Democrats in the Senate, then you're not going to see expansion of the court possible, at least not on a political basis that has been advanced. If they don't, if the Senate retains its power for the Democrats, then I really think it could be a very live issue. And let me just say, I think that factors into Breyer's decision. He wants to be present for this gun case. He really believes that he has the right answers on this, and he can persuade his fellow justices. We'll see whether he spent all summer trying to get Justice Barrett to become friends.
Can I say something?
But let me just say, he's waiting. He believes that next June he can announce his retirement. They will still have the same majority in the Senate, and they can still put through a justice in 5 weeks, like they did with Justice Barrett before the midterms. Now that assumes nobody dies of a heart attack or gets hit by a bus. But that's
and that's actually the point. I'm curious what it's like to have a court meeting in person with the median age would be in the high 70s. I mean, it's a very old court, and it wouldn't take too many breakthrough infections. And just to show, that's, I think, part of what is so worrisome about an all-powerful Supreme Court like this is that, one random COVID case, and now all of constitutional law is potentially different. But anyway, I hope that doesn't happen. But
yeah. Well, and who knows where it would hit.
Right. But I want to be clear. I don't want that for anyone. But it just that's what's scary about it, is that it depends on the personalities, and that doesn't feel democratic.
Yeah. Boy, that's a whole challenge to Article 3, right? We'll just change Article 3. I'm not sure. I don't know. Get rid of the personalities.
Well, personalities are good, but we definitely lose something if we don't have an impartial judiciary. If it's all politics all the way down, it's even more dysfunctional. But if the politics are driving who the justices are, then it's hard for me to distinguish.
Okay. Other questions in the room? No. There is this other question here about Gundy. So Gundy has to do with non-delegation. You all know this, right? The theory is Congress cannot delegate all of its power to an administrative agency. They have to set some intelligible principle, says the court. It's not in the Constitution. When they delegate power. Delegation is fine, but they have to have a principle that the agency can follow to enact rules and sub-rules and things like that. Gundy involved a very close case having to do with the sex offender statute. And effectively, Justice Alito was the deciding vote. And he said, I might agree with the three dissenters to overrule the non-delegation idea, to apply this intelligible principle standard in a much more rigorous way and prevent delegations. I might do that because there are three dissenters. But I don't think that until there's a fourth vote or a fifth vote, I'm going to do that. And most people think he voted in favor of the delegation in that particular case because it involved sanctions against sex offenders, and he's a former prosecutor and didn't like sex offenders. What's interesting is he had 4 votes to grant cert. He could have, if there are 4 votes, they could have. But now there's a 5th vote and a 6th vote maybe. And a lot of people think that they will revisit the non-delegation doctrine and look for a case where Congress has said something very vague in its delegation of authority to some agency, and they will grant cert in a case where someone challenges that because they don't like the rule that's been enacted by the agency, and change the standard. It's not clear what they would do with that, right? I mean, Justice Breyer wrote in a dissent that if you can't delegate authority to agencies, you can't get much done. Congress itself seems to be unable to get anything done. The president can only do certain things. The legislative power is with the Congress, not with the president. And if you don't have delegation, right, we would go back to the pre-1930s very limited scope of federal government, if you will. So he says it's just really not practicable to be able to do this. So again, it's one of those cases where Justice Barrett might say, I don't know what to replace it with. I mean, I don't like the standard so much, but I don't know what to replace it with. So it's an open question. I think it's right that the change in the membership in the court probably changes the votes in a particular case on if one comes up. I don't know of a particular case that's coming. There is one follow-up on the abortion thing. Professor Ralph, you want to read it? We said we'd go till 1:30. You don't have to stay, but we're happy to have you.
Follow-up question. Why is abortion a state police power? Again, it is a healthcare matter. So I'm not sure why it is a legal issue. Well, states basically have background power to enact all laws that the federal government has not been entrusted with in that sphere. So if it's not a matter of federal constitutional law, then, then the states generally have the power to enact laws to protect their citizens' health, welfare, safety, and so forth. So that's what makes it a state power. Now, the federal government could try to enact a law. But if the federal government does so, the federal government being a government of limited powers, and this by the creation and structure of the Constitution, the federal government would need some form of authority. So Commerce Clause seemingly would be a good source of authority, and Congress is proposing laws to protect abortion as a matter of federal law.
It's a good example of political freezing, though. I mean, the House might pass such a law. There's been legislation in the House under Commerce, and probably is Commerce, it seems to me, but there's not votes in the Senate to get it passed.
So the question is, why is it a legal issue rather than a healthcare issue?
Yeah.
And I guess even if it's a matter of healthcare, we have laws that regulate and set outer limits on healthcare. Even, for example, any medical procedure. Informed consent is a matter of healthcare, but states can enact laws to prescribe what counts as informed consent. And many states have done so in the context of abortion rules.
Like, to ask why something's a legal issue is to undercut the entire fabric of the American world. Everything's a legal issue in the United States. It's it's a God-given thing, and isn't in the preamble, right? Everything can be taken to court. I'm kidding.
Exactly. And now some countries have health as a matter of constitutional law.
Yeah, people say you have a right to health care.
We
Right to
don't,
medical
though,
care.
as a matter of our Constitution. If you're interested in comparative constitutional law, I teach a seminar on that, and other countries take different approaches to these issues. But in the US, as Rory says, everything is a legal issue.
Well, and the issue of freedom of your liberty clearly is a constitutionally protected value. This is why we have fighting about masks. Can you make people wear masks? Can you make people take vaccines? Can you make people do things? And the abortion debate is part of that larger world of autonomy and choice. And then just to add the last dimension to this, or one dimension, it's a gender-based idea that men can tell women what to do with their body, and the legislatures have been controlled by men. That isn't to say that all women support abortion and all men are against it or anything like that, but the autonomy issues and the liberty issues, I think, are real constitutional issues that have to come into play. You might decide that they don't matter. You might decide that some other value is more important, but I think it really has to be viewed, I think, as a constitutional issue and a legal issue, and not just a matter of legislative policy making. So that's my response to that question. John, did you have something you wanted?
No, I totally agree. And it's not just because I'm a lawyer that I think everything is a legal issue, but you'd be hard pressed. There may be some deep recesses of the mind where you can have personal thoughts that are not regulated by the law, but practically everything else, there is a rule around that.
Well, fortunately, the Supreme Court did hold in an old case that you have the right to possess pornography in your home, right? Now, how you get it there?
Stanley against Georgia.
Stanley versus Georgia.
Mere private possession of pornography cannot be made a crime.
Okay.
Although it can be a crime to distribute it, to sell it,
Or even to
make
transport it, right?
or even to transport it.
Yeah. So anyway, and the Warren Court was viewed as just as political in the 1960s as the court is today, from the opposite direction. I mean, when I was young, and this shows you how old I am, is that your cars with bumper stickers in your neighborhood all the time that would say impeach Justice impeach Douglas, impeach Warren, and impeach Brennan, like they would compete as to how many bumper stickers would be made for each justice's name.
Well, I think that is part of the issue is that, if you are liberal and a lawyer, you learn about cases from the 1960s in the Warren Court, and there was this flash of the Supreme Court as a counter-majoritarian and rights protective institution. But in the long scope of history, courts generally are anti-democratic. I mean, if there's a popular issue, the legislature will take care of it, and it's the courts generally that step in to prevent that. So, it's not that this is some particular abomination that we have today. I mean, this is part of what courts generally are conservative forces.
We did have this question at the very beginning. Is it fair to say that Dobbs could be styled by proponents as an update on Roe and not an overruling?
Well, they haven't decided Dobbs yet. So I am speculating, but speculating, I would suggest that it's possible that the court could do a 3-3-3 kind of a ruling where they, update Roe/Casey rather than overturn it in a Fulton-like decision. And instead of overturning the big high-profile precedent, they kind of rewrite it so that they don't need to overturn it. That's the implicit overruling. Or they could do a 5-4 and say, we're explicitly overturning Roe, and then maybe Chief Justice Roberts would join the 4 liberals in dissent, as he did in that shadow docket order in the Texas abortion case. And you've got 5 votes to explicitly overturn Roe. I'm not sure that Chief Justice Roberts wants to go down that route.
The shifting views on this are so interesting because at the time Casey was decided, many people thought that was an implicit overruling of Roe, at least in certain ways.
I agree with that position.
And that Casey changed the law in a very dramatic way. And now we're all thinking, oh, maybe we could just at least preserve Casey, please. So the politics and the ideology of the abortion issue are unbelievably strong. And this United States Department of Justice lawsuit against the Texas law statute, which is set for a hearing, I believe, in October in the district court by the judge who had actually stayed SB 8 and then was reversed. That is itself based on some very interesting theories as to what is the standing of the United States to sue a state, right? It's just called United States versus Texas. It's not a list of legislators and officials. United States versus Texas. It's reminiscent of the Civil War. We, the federal government, are suing the state, and that state is out of line, and we have a standing to seek relief from something we think that they've done, which hurts the interests of the United States. I think it's a very interesting legal theory, and it's a very interesting complaint because it states this legal theory in incredibly succinct and explicit terms, and it actually cites a few cases, which you don't see in complaints all the time.
Can I ask a question to my distinguished panelists? Do you think that overturning Roe versus Wade is the end of the abortion issue, or is there something beyond that? Is that the goal, or is there something more that can happen?
It's not the end of it. I mean, it's clearly not the end of it because people will still seek abortions.
No, I mean, in terms of
as a matter of constitutional law,
conservative agenda. Is there something
right? Because what will be the next step? It will be to criminalize transportation of people.
So that's what
across state lines.
Well,
is that possible?
Amy Coney Barrett's colleagues at Notre Dame, several of them filed briefs in Dobbs, amicus briefs. A couple of the briefs only argued that Roe should be overturned. But one of the amicus briefs went even further and said that as a matter of constitutional law, the court should declare all abortion to be unconstitutional so that no state could permit abortion. There was an amicus brief that was filed by one of her colleagues, joined by Robert George at Princeton, arguing that the fetus is a person from the moment of conception and that its life, the due process clause protects no person should be deprived of their life without due process of law. So for any state to permit any abortion would violate the right to life of the fetus and would be unconstitutional.
And how far away is that?
I think that's too extreme. Even the late Justice Scalia would not have adopted such an extreme approach. So I would say that's too radical an approach.
I
But who
don't
knows?
mean to go to hyperbolic limits here, but I think it's Civil War issue. You have states like California that will protect the right to abortion under state law, sort of to the death. And you have states like Texas and Mississippi, I suppose, and others, who will try to declare that anyone who gets an abortion is guilty of murder and should be prosecuted. And this is a divisive, and you could see the federal government trying to say, well, let's let everybody do what they want, or you could see a Missouri compromise. I mean, I really think the parallels to the debate over slavery are very similar, including the idea that people quickly go from a legal position to a moral position on these issues. So I actually think it's a very important moment, and I think I hope the court recognizes how important that moment is. And interestingly enough, the Chief Justice gets to assign the opinion if the Chief Justice is in the majority. This might be a case where Roberts will struggle to be in the majority, no matter what, so that he can assign it to someone, maybe himself, who he thinks will write the most protective decision for the judiciary, regardless of the rights of this party or that party. And this is what Warren Burger used to do. He would sort of manipulate what he said at conference so that he could say, oh, I get to assign it. I think Roberts hasn't done that in the past. I think he's actually played pretty fairly. But this may be one where he really works hard to say, well, I think I'm in the majority on this one, and I'm going to keep the case. At which point you'll see 5 different opinions. So,
Good prediction, Rory. I think that Roberts would struggle to do that.
yeah, I don't know that he'll want to be in that majority, but he'll figure out. I mean, we'll see. We'll see. I mean, I think you're going to see more than 2 opinions in Dobbs. I really do. This questioner has followed up by what they meant by update. Professor Brown, maybe you want to look at that. Our in-person audience is dwindling.
Science had advanced. And so to limit abortion to say 12 weeks as opposed to Roe's 20 to 24 weeks reflects medical advancements and is not intended to burden a woman's right to choose. Hence an update and not an overruling. Well, the problem is that Roe pretty squarely drew the line at viability of the fetus. And Casey retained and reaffirmed what they label the essential holding of Roe, the line drawn at viability. So to redraw the line at a radically different point, I don't know how you can call it updating Roe. You would be rejecting Roe's viability framework. Now, I guess they could say, well, facts have changed and our understandings of facts have changed such that the Roe viability line no longer makes sense in light of these medical technological developments. So we're updating to take into account new facts and we're going to redraw the line. And so the questioner, I think, is correct. They could label that a reworking of Roe and not an abandonment of Roe. And that's one way to implicitly overturn Roe and say Roe still remains. Women have a right to terminate their pregnancy prior to 12 weeks in the first trimester of pregnancy. But after 12 weeks, there's no right.
Which is much like the 8th Amendment too. It's an evolving standard.
And actually that coincides with a lot of other countries. If you look at comparative abortion law, most countries, abortion is freely and readily available in many countries in the first trimester. So roughly the first 3 months, 12 weeks of pregnancy. But it may be more regulated or less available after that period. So that might bring us in line. Now, actually, that's theoretically the comparative abortion law, but in actual practice, abortion is more widely available in many other countries where it's not a fundamental right than it is as a practical matter in the US, even though technically, theoretically, it's a fundamental right here.
This is what's so wonderful about doing this panel every year is I learn every year from my colleagues. Who knew that there were rights outside of the United States? That's just, I didn't know that. That's great. Other questions in the room or online? We're not getting any. I think we're going to call it an end. Thank you so much to you for coming and to you for coming and to our panelists. Thank you.